SwayamPrabha. Digital India. Educated India.
Hello friends, welcome to the class of Maritime Law, Lecture 13. I am Dr. Ashutosh Acharya, Senior Assistant Professor from Law Center 2, Faculty of Law, University of Delhi. Well friends, in this class we will discuss and talk about law of salvage and towage, two important aspects of marine transaction wherein whenever either a vessel floating not fitted with machine or engine has to be shifted from one place to another place, towage comes into being, tugging comes into being. Whenever a ship is in distress or is in problem, or the ship is damaged and has converted itself into a wreck, the cargo has converted into itself a wreck or is damaged or is now outside the ship due to collision, accident or any other kind of scenario which led to spillage of the cargo. Cargo may be a packaged cargo, cargo may be oil or any other substance which may be chemical or perishable or non-perishable goods. When such distress, difficult spillage, difficult situation comes into being, then the act of salvage, or in normal scenarios when a particular vessel has to be towed from one place to another place, then towage comes into being respectively. And to govern this particular aspect of safeguarding the goods, safeguarding the ship or moving a particular vessel from one place to another place, law of towage comes into being. So, this law of salvage or law of towage comes into being to govern and regulate the aspects pertaining to safeguarding the goods or ship or movement of goods or ships from one place to another place. Now, as far as marine salvage is concerned, it is a very peculiar and specific kind of activity, wherein we will see in this particular lecture that when such an activity is undertaken, it is undertaken by particular specific individuals, certain group of people which are expert and involved in particular kind of activity known as marine salvage. They have expertise pertaining to safeguarding the interest of the ship owner, the charterer or the interest of the cargo owner, which may be a seller or may be a buyer depending upon their own transaction. Sometimes you must have seen that a vessel which is not accompanied with any engine or is not fitted with any kind of engine, mechanical movable engine placed on that particular floating body, we just see certain cargoes placed on that particular vessel. And if it has to be moved from one place to another place, especially in scenarios where ships cannot move, in those scenarios largely we see that those vessels are moved or transported from one place to another place by a smaller ship carrying larger cargo on a larger platform. So, it is just a movement of platform. So, you cannot move a platform on its own. So, mechanical movement takes place through tugging it or towing it. We will look at it in a on a larger scale as far as our discussion in today's lecture is concerned. So, we will first discuss salvage in detail, what is the international law that is to be complied with as far as salvage is concerned, and then we will look at towage and tug as far as international law is concerned. We will also look at the Merchant Shipping Act, how Merchant Shipping Act takes care of the salvage activity, and how Admiralty Law of India 2017 also takes care of salvage as far as claims with respect to salvage are concerned. What is the status of salvage claim as far as Admiralty claims are concerned will also be discussed in today's class. Now, if you see, marine salvage is the saving of a ship, its cargo or any other marine property from danger in navigable waters that without the rescuer's help would have resulted in the loss or destruction of the property. Now, when we look at salvage, there are primarily three elements that must come into being, that must come to the fore as far as salvage is concerned. So, if you look at three elements of salvage, they are: the property to be salved must be in peril. Peril means risk. So, the property, some property must be at risk. Now, property can be divided into two parts as far as marine activity is concerned. One property would be the ship itself, the other property would be the cargo. Cargo can, as I said, be divided into various parts: a perishable good or a non-perishable good, it may be oil, it may be chemical substance, or it may be any other packaged goods. Secondly, the action should be voluntary, that is, the salvage must not be under pressure or must not be under authority. Salvage is a kind of, can be considered to be duty under national systems. However, primarily as far as its origin etc. is concerned, we see that salvage contract has to be entered into between the salver and the one whose property is to be salved. So, contract has to be based on consensus ad idem, and therefore, it is a contract, and therefore, there must be free consent of the salver, which means that it must be voluntary as far as saving of goods and property at sea is concerned. So, the action should be voluntary, that is, there must not be any legal obligation for the salvers to try and save the property. However, once the property is saved, it would be the legal obligation to comply with the contract that has been impliedly entered into between the salver and the person or the ship owner whose property, either the goods or the ship, has been salved. Thirdly, the action should be successful, in that there must be some part of the property saved from which a salvage award will be paid. Now, friends, it means to say, if you look at this particular line, it means to say that unless and until any property is salved, no contract can be enforced, that is, no payment will be made. However, in contemporary times, we have seen change in scenario, that if no pay is made because there was no cure, then it will discourage the whole salvage industry, and no salver would be willing to salve any property, either the ship or the goods. In such a scenario of discouragement, the salvage industry will be diminished, or you can say will not function properly. So, therefore, there must be some incentive that must be brought into picture as far as efforts of the salvers are concerned. So, therefore, in modern or contemporary legal system, especially the international law, we see that an improved or improvised version of claim has been brought into picture, and that is that even if some effort was made, even if no cure was an outcome, even if no property was salved, but some efforts were made to salve the property, for those efforts also some payment will be made for the efforts. This is done to encourage the salvage industry, which is a necessary element as far as marine transaction and marine industry is concerned. Further, this is because the concept of salvage is that a successful salver is entitled to a reward, which is a proportion of the total value of the salved property. So, largely there is a reason behind no cure no pay. However, as I said, in the contemporary times it has been improvised, that is, for efforts also the payment will be made to a certain extent. Now, what are the different kinds or different types of marine salvage? In different scenarios, different salvage comes into being. So, based on different circumstances and based on different scenarios, we have different kinds of salvages. First one will be offshore salvage. These operations encompass stranded or sunken ships in open waters and are often too challenging, as the ships would be exposed to sea waves and weather. Secondly, harbor salvage. This is not as much as the same offshore salvage, since being less challenging for the operations, cover stranded or sunken ships in sheltered water and are unhindered by the natural conditions like intemperate weather or waves and currents. So, the difference is very simple. which also results into the natural outcome of the exercise that is undertaken by the salvers. In an offshore salvage, obviously due to the flowing shores, due to the flowing tides and the natural conditions present in between the sea, it presents a very difficult kind of problem, or it is a challenging situation which is in front of the salvers as far as offshore salvage is concerned. But at harbors we do not see such problems coming into being, and it is comparatively easier to undertake harbor salvage, and therefore, the element of exercise gets reduced in harbor salvage. Thirdly, we have cargo salvage. This is even more important sometimes than salvaging the ship itself, as the cargo on board may pose an imminent threat to the marine environment. Now, friends, as I have already told you that a cargo may be contained of any material, may be perishable or unperishable good, especially in scenarios where the cargo contains oil, where the cargo contains material which is hazardous to the marine environment, which may be a hazardous chemical substance, which may be obnoxious substance. In such situations, the marine life and marine environment can be adversely affected. So, therefore, in order to protect the marine environment, marine life, the salvage activity requires hardened and absolute intention to protect the marine environment, and in order to implement that particular intention, in order to implement that particular exercise, a higher level of exercise is required, a higher level of technical expertise also required, much more exercise is involved with respect to clearing the oil or chemical substances from the sea. Now, let us assume a situation where there is an oil spill in between the sea. How difficult it would be to collect tons of oil that is spilled on the marine environment, ultimately leading to marine degradation and damage. So, number of species of ships or of shark or whale or whatever may be the marine life present in that particular region, if oil spill is there or if chemical spill is there, it will ultimately and definitely lead to damage of marine environment. Salvage activities, if undertaken to whatever extent it may be, will result into saving marine environment. Now, one of the best example of such a situation that can be taken is Torrey Canyon incident, wherein Torrey Canyon, a tanker traveling from Kuwait, met with an accident, and ultimately there was an oil spill near the English coast, and the oil started coming near to the shores of England. Ultimately, the English authorities had to bombard that particular region. Salvers did play their role in cleaning and clearing the oil from the respective marine area. However, they were not completely successful, and ultimately such drastic measures had to be undertaken. So, therefore, the role of salvers become very important as far as clearing and cleaning of sea area is concerned, in order to save marine life and marine environment. So, therefore, cargo salvage is one of the most important area as far as salvage activity is concerned. Fourthly, we have equipment salvage. Another focus is on salvaging large machinery components like engines, turbines, driving systems by dissecting, disassembling or destructing the hull if these equipment survive the intrusion of sea water. So, again a tedious task for the salvers, that is to save the equipments of the ship, wherein the equipments of the ship might be in huge quantities and large in their size. Solving them is a tedious task because they have to be broken into parts, they have to be opened into different parts, and then they have to be solved. And this again requires a very intense exercise on the part of the salvers. Fifthly, we have shipwreck salvage, that is, the ship is no more into a fit condition, however, the wreckage has to be cleared so that marine pollution can be avoided. Therefore, this is a low priority task than the above mentioned salvage operations. The objective is to disembarrass the water area of hazardous or unsightly substances using the most practical and cheapest method possible. One of the most common methods is to cut the hull into very small sections and refloat the parts and scuttle it in deeper waters. Hence, we have already understood in the previous lecture what do we mean by the hull of the ship, that is the center of the ship based upon the keel of the ship. So, the main part of the ship, which is the center of the ship, which contains all the machineries, the cargoes, etc., would form the hull of the ship. And if it has to be removed, since it is very large in size, it has to be cut into pieces and only then it can be removed from the ship, and the marine environment can be prevented from pollution. Further, we have afloat salvage. When a ship is damaged, but it still floats in the water, the salvage operation is called afloat salvage. And then we have clearance salvage. These operations are carried out as the aftermath of catastrophic events like hurricane, tsunami and war, etc. In clearance salvage, a number of shipwrecks are scavenged or removed coordinately to clear out the passage in a harbor or waterway that can be blocked for navigation by multiple obstructions with ships varying degrees of damage due to events like fire, collision or explosions, etc. Now, what does the International Maritime Organization has done as far as salvage is concerned? IMO has prepared the salvage convention, prepared a draft, and then it came up with the final convention, which was approved by the states, and then it is now in force. 1989 convention has very peculiar updation. Largely it is focused on the compensation aspect. So, the highlight of the updated convention is the enhanced compensation regime, because earlier based upon Lloyd's reports form, that is working under the Lloyd's market, we see the form had a title known as no cure, no pay. So, if no cure is done or no property is salvaged which is useful, then no payment will be made. So, all of the exercise of the salvers would go to wastage and no compensation, no remuneration would be paid to them. So, therefore, this would, as I said, that was discouraging the whole industry. So, the new convention came up with an updated compensation regime, which makes the level playing field for salvers as well or salvage industry, and provides for an enhanced compensation regime, which removes or replaces the older rule of no cure, no pay. So, salvers are those engaged in salvaging ships or the cargo that it carries. In 1910 Marine Convention held at Brussels on salvage provided rewards to salvers only upon successful completion of a salvage operation, that is no cure, no pay principle. This principle often resulted in those who wanted to help to turn a blind eye to a marine accident, as they were not sure of getting paid for their efforts. In most cases, such a situation caused pollution or contamination of the surrounding environment from the wreckage of a ship. To set this right, the International Maritime Organization's Salvage Convention of 1989 brought about changes that would incentivize salvers to step in and act to prevent further damage to a stricken vessel, its cargo, and therefore, the nearby environment. Article 1 of the new convention talks about the definition, and for the purposes of this convention, clause A, salvage operation means any act or activity undertaken to assist a vessel or any other property in danger in navigable waters or in any other whatsoever. Clause B, vessel means any ship or craft or any structure capable of navigation. Property means any property not permanently and intentionally attached to the shoreline and includes freight at risk. Damage to the environment means substantial physical damage to human health or to marine life or resources in coastal or inland waters, or areas adjacent thereto caused by pollution, contamination, fire, explosion or similar major incidents. So, if you look at clause C, you will see that property not only includes some tangible property, but also includes the freight which is at risk because the ship did not reach to its destination, whether the freight should be paid. So, the overall property of the ship would also include the freight of the ship. So, when calculation of the compensation is made with respect to the salved property, then the calculation would also include the freight of the goods that were to be transported from one place to another place. If you look at clause D, it talks about in the last line similar major incidents. So, it opens up an area that if any natural occurrence is there of fire or tsunami or any other accident, then it will be considered to be damage to the environment, and it will mean substantial physical damage to human health or to marine life or resources in coastal or inland waters or areas adjacent thereto. Further, we have payment means any reward, remuneration or compensation due under this convention. Now, all of these things are with respect to the salvers or in favor of the salvers for the salvage. Organization means the International Maritime Organization. Secretary General means the Secretary General of the organization, that is the IMO. Article 2 talks about application of the convention. This convention shall apply whenever judicial or arbitral proceedings relating to matters dealt with in this convention are brought in a state party. And Article 3 talks about platforms and drilling units. This convention shall not apply to fixed or floating platforms or to mobile offshore drilling units when such platforms or units are on location engaged in the exploration, exploitation or production of seabed mineral resources. So, must have seen those areas, platforms where oil drilling machines are placed. So, since they are fixed, they do not fall within the domain of this particular convention as far as their salvaging is concerned. So, if there is any oil spill in an area where oil drilling is taking place and that particular drilling area faces any oil spill, then this particular convention will not cover that particular platform or oil drilling area. Further, Article 4 talks about state owned vessels. Without prejudice to Article 5, this convention shall not apply to warships or other non-commercial vessels owned or operated by a state and entitled at the time of salvage operations to sovereign immunity and under generally recognized principles of international law unless that state decides otherwise. Clause 2, where a state party decides to apply the convention to its warships or other vessels described in paragraph 1, it shall notify the Secretary General thereof specifying the terms and conditions of such application. So, largely warships etc. are not included under the convention. However, if the flag state wants to include them, it must notify to the Secretary General of the IMO. Article 5 talks about salvage operations controlled by public authorities. Clause 1, this convention shall not affect any provision of national law or any international convention relating to salvage operations by or under the control of public authorities. Nevertheless, salvers carrying out such salvage operations shall be entitled to avail themselves of the rights and remedies provided for in this convention in respect of salvage operations. Lastly, the extent to which a public authority under a duty to perform salvage operations may avail itself of the rights and remedies provided for in this convention shall be determined by the law of the state where such authority is situated. Article 6 talks about salvage contracts. This convention shall apply to any salvage operations save to the extent that a contract otherwise provides expressly or by implication. So, there can be an express contract, that is before performing the duties of salvers or exercising salvage activity, a contract may be entered into upon a standard form. So, the most sought for standard form is under Lloyd's market, Lloyd's report form, wherein the parties can sign it immediately and salvage activity can be undertaken. However, it may be voluntarily also undertaken without entering into contract expressly, and impliedly also if salvage is done, that implication wherein the ship owner or the concerned authority does not object to such salvage or is in dire need of being salved and the salver salves them, either the cargo or the life or the wreck of the ship or the ship itself, the property of the ship, then that would be a contract by implication, need not be an express contract all the time. The master shall have the authority to conclude contracts for salvage operations on behalf of the owner of the vessel. The master or the owner of the vessel shall have the authority to conclude such contracts on behalf of the owner of the property on board the vessel. Since the owner of the cargo or the owner of the vessel might not be present at the time when the mishap happened or when the salvage is required, master has the complete authority as far as the goods are concerned, as far as the ship is concerned. Nothing in this article shall affect the application of Article 7, nor duties to prevent or minimize damage to the environment. Article 7 talks about annulment and modification of contracts. A contract or any terms thereof may be annulled or modified if the contract has been entered into under undue influence or the influence of danger and its terms are inequitable, or the payment under the contract is in an excessive degree too large or too small for the services actually rendered. Chapter 2 talks about performance of salvage operations, duties of the salver and of the owner and master. Now, this is a very important chapter as it identifies what duties and rights exist as far as the salver as well as the owner or the master is concerned, in order to calculate the compensation, in order to identify the liability and claims, etc. So, Article 8 talks about duties of salver and of the owner and master. Clause 1, the salver shall owe a duty to the owner of the vessel or other property in danger to carry out the salvage operations with due care, in performing the duties specified in subparagraph A, to exercise due care to prevent or minimize damage to the environment. So, the salver must function and work as per the best ability and quality of his caliber, must be duly diligent as far as undertaking of salvage activity is concerned. Whenever circumstances reasonably require, to seek assistance from other salvers, and to accept the intervention of other salvers when reasonably requested to do so by the owner or master of the vessel or other property in danger, provided however that the amount of his reward shall not be prejudiced should it be found that such a request was unreasonable. The owner and the master of the vessel or the owner of the other property in danger shall owe a duty to the salver to cooperate fully with him during the course of the salvage operations, in so doing to exercise due care to prevent or minimize damage to the environment, and when the vessel or other property has been brought to a place of safety, to accept redelivery when reasonably requested by the salver to do so. Article 9 talks about rights of the coastal states where such a damage to ship or damage to goods have happened. Nothing in this convention shall affect the right of the coastal state concerned to take measures in accordance with generally recognized principles of international law to protect its coastline or related interests from pollution or the threat of pollution following upon a maritime causality or acts relating to such a casualty, which may reasonably be expected to result in major harmful consequences, including the right of coastal state to give directions in relation to salvage operations. So, the best example for this particular aspect would be Tory Canyon incident, where, as I said, the English had to bombard the area where they bombard the ship which was releasing the oil continuously, and it was almost getting impossible for the salvage industry to salve all that oil. So, though that was also not easy due to the presence of water, the bombardment was not completely successful, and it was only successful to a very limited extent. The salvage industry, equipped with better equipments and better expertise and technical aspects, can perform better as far as removing or clearing the oil in a particular shore is concerned. However, at the same time, the coastal state is always free to take any reasonable appropriate measure in order to protect its coastline as far as saving of marine life and life otherwise is concerned. Article 10 talks about duty to render assistance. Every master is bound so far as he can do so without serious danger to his vessel and persons thereon to render assistance to any person in danger of being lost at sea. The state parties shall adopt the measures necessary to enforce the duty set out in paragraph 1. The owner of the vessel shall incur no liability for a breach of the duty of the master under paragraph 1. Article 11 talks about cooperation. A state party shall, whenever regulating or deciding upon matters relating to salvage operations such as admittance to ports of vessels in distress, or the provision of facilities to salvers take into account the need for cooperation between salvers, other interested parties and public authorities in order to ensure the efficient and successful performance of salvage operations for the purpose of saving life or property in danger as well as preventing damage to the environment in general. Chapter 3 talks about rights of salvers. Article 12, conditions for reward. Once salvage activity is undertaken or is to be undertaken, what are the conditions that must be taken into account as far as reward is concerned? Salvage operations which have had a useful result give right to a reward. Except as otherwise provided, no payment is due under this convention if the salvage operations have had no useful result. So, this particular provision is again based on the no cure no pay rule prima facie, but we will look in the upcoming provision, especially in article 14, we will see how this particular aspect has been mitigated by providing an additional compensation into being. Now, this chapter shall apply notwithstanding that the salved vessel and the vessel undertaking the salvage operations belong to the same owner. Article 13 talks about criteria for fixing the reward. The reward shall be fixed with a view to encouraging salvage operations, taking into account the following criteria without regard to the order in which they are presented below. Now, if the reward is to be fixed, what is the criteria? Now, clause 1 says the reward shall be fixed with a view to encouraging salvage operations, taking into account the following criteria. The first criteria is the salved value of the vessel and other property. So, what are the features, what are the characteristic features that must be taken into account, what is the basis of identifying and calculating the reward that is to be given to a salver. So, the total amount of the salved property has to be taken into account. This does not mean that whatever is the amount of the salved property is the amount of the reward, no. It is one of the factor that is to be taken into account while any reward is to be made. Secondly, the skill and efforts of the salvers in preventing or minimizing damage to the environment. Now, if you look at offshore salvage, skill and effort is higher as compared to harbor salvage. If the hull is to be broken into parts and then salved, much more intense exercise is required and the skill is comparatively higher. So, in such situations, also we can say that depending upon the cargo, depending upon the spill, if the cargoes are in boxes, saving them or salving them would not be much of a problem. But salving an oil spill is a very tedious task and therefore, higher skill, higher exercise, higher level of exercise is required and therefore, the calculation of reward would be comparative and relative depending upon the kind of salvage activity that has been undertaken. Thirdly, the measure of success obtained by the salver. Fourthly, the nature and degree of the danger. Fifthly, the skill and efforts of the salvers in salving the vessel, other property and life. The time used and expenses and losses incurred by the salvers. The risk of liability and other risks run by the salvers or their equipment. The promptness of the services rendered, the availability and use of vessels or other equipment intended for salvage operations, the state of readiness and efficiency of the salvers equipment and the value thereof. So, in fact, this will also be undertaken that what is the preparedness, what is the readiness as far as the salvers exercise of salvaging the property is concerned. So, whether they were prompt in their actions as far as salvaging the property is concerned, what kind of application of mind was in place in order to salve as much property or maximum property which can be salved. So, in a given period of time, if the maximum property was salved, the reward will be comparatively higher as compared to a situation where not an intelligent or a smart approach was taken and whatever property could have been saved was not saved, compared to it lesser amount of property was saved, then the reward would also be reduced. So, the intensity of exercise that is undertaken given the different factors as we have seen just now in the provision will decide that what will be the reward of the salver. Clause 2, talks about payment of a reward fixed according to paragraph 1 shall be made by all of the vessel and other property interests in proportion to their respective salved values. However, a state party may in its national law provide that the payment of a reward has to be made by one of these interests, subject to a right of recourse of this interest against the other interests for their respective shares. Nothing in this article shall prevent any right of defense. The rewards exclusive of any interest and recoverable legal costs that may be payable thereon shall not exceed the salved values of the vessel and other property. So, in any case the reward will not exceed the salved property, that is the maximum limit. Now, we will discuss article 14, which talks about special compensation. So, the normal compensation is based on no cure and no pay. So, in order to promote and in order to give a push to the salvage industry, article 14 has been inserted, which talks about a special compensation and provides for special compensation regime. Clause 1 talks about and says, if the salver has carried out salvage operations in respect of a vessel which by itself or its cargo threatened damage to the environment and has failed to earn a reward under article 13, that is cure and pay, at least equivalent to the special compensation accessible in accordance with this article, he shall be entitled to special compensation from the owner of that vessel equivalent to his expenses as herein defined. Now, the reward may not be in place if there is no salved property, there is no outcome, there is no result that has been come into being. But then some amount of exercise was undertaken, some trial was undertaken in order to save the property or safeguard the property, which may be ship or which may be cargo. So, some exercise, some expenses were certainly made by the salvers, and it will go all in vain if he or she or the salver is not paid for the effort that he or she has made. So, therefore, a special compensation regime that for the efforts payment will be made to the salver, and therefore, clause 2 says, if in the circumstances set out in paragraph 1, the salver by his salvage operations has prevented or minimized damage to the environment. So, there is no property that has been salved, but at least the salver has minimized the environmental damage. So, for example, if oil spill is there and if the salver has cleaned out that particular region wherein oil spill happened, no property got salved, or if there is a good which is of perishable nature and it got perished because of the sea weather and not being in a proper temperature, the salved goods which is of perishable nature will reduce the damage to the marine environment. So, no good got saved, no positive outcome came out of this salvage. However, the environmental damage got minimized to a certain extent. So, for that particular aspect, that is reduction in environmental damage, the salver would be paid some amount of compensation. So, that is what it says, that the salver by his salvage operations has prevented or minimized damage to the environment. The special compensation payable by the owner to the salver under paragraph 1 may be increased up to a maximum of 30% of the expenses incurred by the salver. However, the tribunal, if it deems it fair and just to do so, and bearing in mind the relevant criteria set out in article 13 paragraph 1, may increase such a special compensation further, but in no event shall the total increase be more than 100% of the expenses incurred by the salver. Salver's expenses for the purposes of paragraph 1 and 2 means the out of pocket expenses reasonably incurred by the salver in the salvage operation and a fair rate for equipment and personnel actually and reasonably used in salvage operation, taking into consideration the criteria set out in article 13 para 1 H, I and J. So, we must also note down here that if the salver is not clearing the area where the pollution happened, the ship owner would anyways be liable for such a damage, or any other body would be liable. So, somebody has to pay for that particular spillage and environmental damage. So, why not pay to the salver which will reduce the environmental damage before time or in time, we may say. So, it is a kind of activity which comes in place before time, and you can actually go and pay to the solver who has reduced the environmental damage before time. The total special compensation under this article shall be paid only if and to the extent that such compensation is greater than any reward recoverable by the solver under article 13. If the solver has been negligent and has thereby failed to prevent or minimize damage to the environment, he may be deprived of the whole or part of any special compensation due under this article. Article 15 talks about apportionment between solvers. The apportionment of a reward under article 13 between solvers shall be made on the basis of the criteria contained in that article. The apportionment between the owner, master and other persons in the service of each solving vessel shall be determined by the law of the flag of that vessel. If the salvage has not been carried out from a vessel, the apportionment shall be determined by the law governing the contract between the solver and his servants. Salvage of persons, no remuneration is due from persons whose lives are saved. Also, a salver of human life who has taken part in the services rendered on the occasion of accident giving rise to salvage is entitled to a fair share of the payment awarded to the salver for salving the vessel or other property or preventing or minimizing damage to the environment. Article 17, services rendered under existing contract. No payment is due under the provisions of this convention unless the services rendered exceed what can be reasonably considered as due performance of a contract rendered into before the danger arose. Article 18 talks about the effect of salvers misconduct, and article 19 talks about prohibition of salvage operations. Chapter 4 talks about claims and action. Article 20 talks about maritime lien. Nothing in this convention shall affect the solver's maritime lien under any international convention or national law. So, if you talk about India in under Admiralty Act of 2017, salvage acts are also considered to be within the domain of maritime claims. So, if salvage remuneration or reward or compensation is not paid for the salver's activity or conduct or exercise to safeguard the property or to minimize the environmental damage on behalf of the owner or the ship owner, then it can lead to claim of maritime lien as well. Or you can say a charge can be created upon the goods or upon the ship. So, a salvage claim is a type of claim which is on priority, and when I say priority, it means that once a salvage activity is undertaken of whatever nature that we have discussed so far, then the ship owner is liable to pay, and if the ship owner does not pay or the cargo owner does not pay to the salver, then a charge will be created upon the ship or the cargo, and an action in rem can be brought by the salver against the ship or the cargo. That is, the salver will have a priority claim over the ship that has been salved or the wreck of the ship or the goods that have been salved. So, whatever useful property is there, the salver will have a priority claim over those goods or over that property. Now, once the ship owner wants to recover it, first the ship owner or the cargo owner will have to pay the salver. Unless and until the salver's claim is satisfied, the action in rem or the charge that has been created over the property will resist or will continue to exist over those particular goods. And accordingly, if you look at Admiralty Act, before the High Court a claim can be brought and the ship or the goods can be detained as far as those salved goods are concerned, and can only be released by furnishing security by the owner of the goods or by the owner of the ship. Further, the salver may not enforce his maritime lien when satisfactory security for his claim, including interest and costs, has been duly tendered or provided. Article 21, duty to provide security. Upon the request of the salver, a person liable for a payment due under this convention shall provide satisfactory security for the claim, including interest and costs of the salver. Further, Article 22 talks about interim payment. The tribunal having jurisdiction over the claim of the salver may, by interim decision, order that the salver shall be paid on account such amount as seems fair and just, and on such terms, including terms as to security where appropriate, as may be fair and just according to the circumstances of the case. Article 23 talks about limitation of actions. Any action relating to payment under this convention shall be time barred if judicial and arbitral proceedings have not been instituted within a period of 2 years. So, there is a limitation period of 2 years within which arbitral action or judicial action has to be brought in. Merchant Shipping Act 1958 also talks about the salvage activity. Somewhere down the line it is in consonance with the International Convention on Salvage, and section 402 talks about salvage payable for saving life, cargo or wreck, where services are rendered wholly or in part within territorial waters of India in saving life from any vessel or elsewhere in saving life from a vessel registered in India, or in assisting a vessel or saving the cargo or equipment of a vessel which is wrecked, stranded or in distress at any place on or near the coast of India, or by any person other than the receiver of wreck in saving any wreck, there shall be payable to the salver by the owner of the vessel, cargo, equipment or wreck a reasonable sum of salvage having regard to all the circumstances of the case. Now, with respect to all the circumstances, what will be the basis of calculation of reward? We have already discussed under the International Convention. Clause 2, salvage in respect of the preservation of life when payable by the owner of the vessel shall be payable in priority to all other claims for salvage. Where salvage services are rendered by or on behalf of government or by vessel of the Indian Navy or the commander or crew of any such vessel, the government, the commander or the crew as the case may be shall be entitled to salvage and shall have the same rights and remedies in respect of those services as any other salver. Now, this will be all about salvage as far as Indian law, as far as international law in detail is concerned. What is the basis, how is the reward calculated, and how is the special compensation regime comes into being, what is the limit of paying of salvage, where does the claim of salvage stands, what type of action can be brought in before the court as far as the salvage activity is concerned. We have discussed all of that particular aspect. Now, let us discuss and talk about in brief towage and tug. Tow and tug are an essential aspect of marine transaction, wherein certain ships require towage in case it is in distress, cannot move from one place to another place. It can be tugged also. In certain geographical regions, a ship cannot sail on its own, or the cargoes cannot be moved through large ships. So, in such situations, certain platforms are required which does not go beneath the water or under the water just like ship. So, if you look at ship, almost half of the ship is underwater in order to manage the buoyancy of the ship, so that maneuvering can be done in a positive manner. But when in certain areas such deep ingrained ships cannot be traveling or cannot be allowed to travel, in such situations certain platforms are created. Over those platforms the cargoes are placed, and with the help of smaller ships they were towed from one place to another place. Also, sometimes a ship has to be moved from one place to another place, it can be tugged along with, and this tugged ship can be moved from one place to another ship. Sometimes a particular platforms are to be moved from one shore to another shore by pushing those platforms with the help of ship. Specially designed ships come into being especially to undertake such task. So, ship need not always be a pointed one, where pointed ships are useful to travel in at a longer distances or even at a shorter distances in order to cut the water, and which makes the sailing of the ship easier. But if you look at ships especially designed for tugging and for towing, you will see that they are largely in a rectangular shape. The front is flat, the flat front helps them to push the platforms in an easier manner. If the front of the tugging ship or the towing ship is pointed, it will be not adjusting with the platform that it has to push. So, to tow a ship not an issue, but to push a ship you require the front of the ship or front of the vessel to be flat, so that it can be pushed easily. So, similarly we see this particular aspect, what is the law pertaining to towage and tugging. Contemporarily we take towage for granted, but it is a service which in its modern guise at least is a little more than 180 years old. Modern towage was born with the advent of the purpose built steam tug in 1820s. Until that time sailing ships had to fend for themselves, with occasional assistance given each other within the limitations of maneuverability with which they were burdened. They sailed up estuaries, down straits, and came alongside quays with a minimum of help from anything other than a fair wind and an easy tide. In Princess Alice, Dr. Lushington described towage thus as, without attempting any definition which may be universally applied, a towage service may be described as the employment of one vessel to expedite the voyage of another, when nothing more is required than accelerating her progress. The towage contract may be written or verbal, and unlike salvage, the contract may predate the circumstances which give rise to necessity of the tow. Towage usually involves a tug, though the same principles apply to any vessel towing another. The vessel towed may have her master and crew on board and may be manned by only a runner crew supplied by the tug, and may even be unmanned altogether. In the later instance, she is referred to as a dead ship. Daily hire, lump sum or fair rate. Towage contracts are negotiated upon the basis of daily hire being payable for the duration of the tow, a lump sum rate for an agreed towage operation, or fair rate for the job at hand. In the later instance, the parties may agree beforehand to submit the assessment of the towage fee to an arbitrator after the event. Ordinary or extraordinary towage. In Kingalok, Dr. Lushington drew a distinction between ordinary and extraordinary towage. The main reason for such a distinction is that only ordinary towage may be converted in appropriate circumstances to salvage. Ordinary towage is that which takes place for the purpose of expediting a vessel on her voyage, either homeward or outward. Where a service has been commenced as an ordinary towage service, the vessel being in no distress for the mere purpose of expediting the voyage, if it happens that a salvage service unexpectedly becomes engrafted upon it, the towing vessel may not be bound to take the ordinary reward for a towing service. Towage or salvage. In contrast, no engraft of a salvage reward over and above the agreed towage rate is normally allowed in extraordinary towage, regardless of what circumstances intervene. Where a master of a towing vessel, with his eyes open, sees another ship in any way disabled and makes a bargain cognizant of all the facts necessary to be known, he must be bound by that bargain, and any accident that may happen afterwards, any difficulty that may arise, any delay that may be interposed in the performance of that service, he of course must put up with, because he takes the chances and makes a bargain to cover all such risks as these. I therefore repeat that wherever a bargain is made in good faith for the towing of a vessel, I will not engraft upon it, whatever may be the circumstances that subsequently occur, any additional reward beyond that compensation which is stipulated to be paid by the mutual agreement between the parties. Now, what does this mean? This means to say that, let us say there is a vessel which is in distress and cannot move from one place to another place because of some mishap that has happened, either due to mechanical happening of mishap or external. If it has to be moved from one place to another place, and if a smaller another ship is carrying it to the shore or carrying it to the required destination, then whether it will qualify to be a salvage or to be a towage. Now, in such scenario, if the ship that is carrying the another ship which is not in a position to move, let us say ship B is not in a position to move and ship A has entered into contract to move that particular ship from one place to another place, and if it is towing it, whether such towing would fall within the domain of salvage or will fall within the domain of towage. If the contract that is entered into between both the parties is that of towage, then the compensation regime of towage will come into being, and if any wrong happens to that particular ship later on, it will still be a towage, and any further exercise that would be undertaken by the towing ship to safeguard the interest of the ship B would not be counted as salvage activity. So, it is a part of bargain that has to be entered into between the parties. The negotiation will conclude that whether the contract that has been entered into between the parties is a salvage contract or a towage contract. So, obviously, the ship that is being towed would like to be entering into a towage contract rather than salvage contract, because in a salvage contract, if any wrongful act happens, extra amount of compensation will have to be paid, and then which would be pre-agreed. Now, if later on if it is done, then obviously later on the compensation will be calculated based upon salvage convention, wherein implied salvage activity will fall in, but not express activity will come into being. But if it is a towage one, obviously salvage convention will not get applicable, and then towage would be the nature of contract as far as that towing of ship is concerned. So, in the Liverpool, this principle was confirmed. Whilst it is the duty of the court to remunerate all salvors for salvage services, the court has an equal duty to see that a little departure from the exact mode in which that contract is to be performed is not magnified so as to convert towage to salvage. But the hard line of the Kingal in relation to extraordinary towage, where the tow is disabled or in other known extraordinary circumstances, should be tempered by the clear principle that where a towage contract, whether ordinary or extraordinary, is interrupted by a supervening impossibility, the tug is thereby released from its towage contract and is then free to render salvage services to tow, for which it may earn a salvage reward. Now, further we have the Minnehaha, wherein the House of Lords set the parameters. When a steamboat engages to tow a vessel for a certain remuneration from one point to another, she does not warrant that she will be able to do so and will do so under all circumstances and at all hazards, but she does engage that she will use her best endeavours for that purpose and will bring to the task competent skill and such a crew, tackle and equipments as are reasonably to be expected in a vessel of her class. She may be prevented from fulfilling her contract by vis major or by accidents which were not contemplated and which may render the fulfillment of her contract impossible, and in such case by the general rule of law she is relieved from her obligations, but she does not become relieved from obligations because unforeseen difficulties occur in the completion of her task. Because the performance of the task is interrupted or cannot be completed in the mode in which it was originally intended, as by the breaking of the ship's hawser. But if in the discharge of this task by sudden violence of wind or waves or other accidents, the ship in tow is placed in danger and the towing vessel incurs risk and performs duties which were not within scope of her original engagement, she is entitled to additional remuneration for additional services if ship be saved. So, it will then impliedly will convert into salvage activity. However, the court must be very careful while doing so. Master's authority to bind his owner and cargo, unlike salvage which requires no contractual nexus to give rise to claim, towage is an entirely contractual agreement. Generally, a master has authority to bind his owner to all necessary and reasonable contracts and obligations in the navigation and management of the vessel. So, there is no implied towage activity that would come into being as far as towage activity is concerned. Now, if you look at towing and tugging, what is the relationship between towing and tugging? It is the relationship of command and responsibility. Generally, the tug is regarded in law as the servant and agent of the tow. The authority is clearly established that the tow has control over the tug. The tug and tow are engaged in a common undertaking of which the general management and command belong to the tow. As Dr. Lushington has pointed out, it is essential to the safety of the vessels being towed that there should not be a divided command, and convenience has established that the undivided authority shall belong to the tow. The pilot, if there be one, takes his station on his tow, and the officers of the tow are usually, as in the present case, of a higher class and are better able to direct the navigation than those of the tug. There are certain duties of the tug, that is warranty of the seaworthiness of tug and ability to perform the towage, then supply a particular named tug or tug of particular capacity, then skill of performance. Tug owner through the actions of competent servants would generally be required to perform certain specific duties such as inspect the tow lines, must take up the tow, by which is meant the tug should prepare all towing bridles, springs, tow wires, ropes. So, all the equipments must be in place and tug must adhere to all the necessary rules and regulations, and there are certain duties of the tow as well, wherein there is duty to disclosure, then tow to be should be in a convenient position, and payment of towing fees has to be there. Then there are liabilities which may be incurred where either party is in breach of its contractual legal obligation. Such breach would found damages claim from wronged party who suffered damages in the result, but third parties may also suffer damage caused by actions of either or both of the tug. There may be damage to the tug or tow. Where the tow is damaged by the tug, the common law allowed the tow to claim from the tug if the tug was negligent. Also, there can be damage to the third party property where the liabilities generally follow the master servant relationship and responsibilities of command. The tow is thus usually liable because it is in command as far as the tow and tug relationship is concerned. So, we see the relationship between tug and tow, what are the duties and liabilities in general, and how salvage and towage come into being, what is the difference between towage and salvage. Towage is also recognized as a claim under Admiralty Act of 2017 as a claim where if payment is not made, it will give action to be brought by the claimant against the owner of the cargo or the ship that has been towed or tugged. So, with this I complete the discussion over law of salvage and towage and also tugging, and I thank you for your patient listening. Namaskar.